pleasure to be a real pleasure to be here at UNAM. They're being fantastic hosts. The facilities have been marvelous, and the hospitality, of course, has been fantastic. So just thank you very much to our hosts. My name is Ian Laird. I am co-chair, along with Dr. Jose Antonio Rivas, of World Arbitration Update, who has co-organized the conference and helped set up some of the panels. And the next panel is a really very apropos one, following the comments of Meg Kinnear that we've just heard. It's titled Do's and Don'ts in Investment Arbitration, Arbitrators and Party Representatives. And we'll have the opportunity to dig into some of those issues and urban myths and so forth that Meg was talking about, but get into some of the practicalities of how these arbitrations operate. And we have a great group here today, and I'll ask our moderator, Nick Lawn from Van Balis and Belly Firm in London, to provide introductions. I just wanted to thank Nick for coming today and organizing this group. I think we'll have a fantastic discussion. Nick is experienced in international arbitration and investor state arbitration, and I think we'll do a great job on this panel. So thank you, Nick, and I'll pass over the microphone and welcome everyone to World Arbitration Update. Thank you.
Great, so welcome to the first panel of the inaugural session of the Mexico City Investment Arbitration Days 2023. Firstly, I'd like to thank UNAM and the Faculty of Law for hosting us, and the organizers for inviting me to moderate this first panel. Now, when thinking, the first panel is called The Do's and Don'ts of Investment Arbitration. Now, when first thinking about this panel and conceiving what we should discuss, I started thinking about a lecture that I've heard many years ago. It was called ISDS, the Wild, Wild West of International Law and Arbitration. It was a 2018 lecture delivered by Mr. George Cahill, who's a well-known international arbitration practitioner, acting mostly for states. Now, it's just one polemic, and as Meg mentioned, there have been many, many polemics against the ISDS system. But this is a polemic prepared by an insider, someone who acts regularly as counsel within these disputes. And he referred to this as the wild, wild west of international practice. Now, why did he say this is wild, wild west? He says, first, because while one can detect the trappings of a legal system, in a real sense, they are just trappings. There are really no hard and fast rules. Briefs, motions, oral arguments, discovery, and trials are all nothing like what we'd see in a federal court. Speculation and shoddy reporting in newspapers passes as evidence. Misrepresentations of fact, gross miscitations of authorities are rampant, and when discovered, usually go unpunished. Teams of lawyers meet in conference centers and hotels in wonderful locales like Mexico City, all over the world to do battle under the supervision of ad hoc tribunals, flying in from all corners of the world for a few days of drama before they all pack up and rush to their flights home. He sums up listing the deficiencies of the ISDS system. They include the way tribunals are formed, the lack of meaningful arbitrator qualifications or serious standards for arbitrator disqualification, the inherent bias in the system against states, absurd legal interpretations given by sub-tribunals to basic international law principles, interpretations that wouldn't muster in international law 101, and the unchecked powers of arbitral tribunals due to the lack of a reliable post-award review mechanism. So quite a trenchant polemic against the system, but as I said, just one of those criticisms. Now, today's panel is going to be broken into three parts. The first part will be a systemic discussion led by Jose Antonio, where we'll be discussing some of the criticisms and some of the issues that have arisen as part of these criticisms, as well as the responses by the international community to how these criticisms can be addressed. The second and third panels will be more practical, and we will be asking our leading experts on this panel what makes the ideal arbitrator and what makes an ideal counsel in investment disputes. So without further ado, let me introduce our distinguished panel. Firstly, we have Jose Antonio Rivas, who is founding partner, chair of the international arbitration team at X Strategy, where he advises sovereign states and private parties in international, commercial, and investor treaty arbitration, as well as public international law. As well as his counsel practice, Jose Antonio also sits as arbitrator and is adjunct professor of investment treaty arbitration and public international law at the Georgetown University Law Center. Jose Antonio was also, most importantly, co-founder of both the World Arbitration Update and the Washington Arbitration Week. We have Mr. Eduardo Sequeiros, who's formerly a partner at Hogan Lovells, widely recognized as one of the leading lawyers in Mexico and recognized by chambers as one of the most demanded arbitrators in Latin America. He sits as arbitrator in both commercial and ISDS cases and has sat as arbitrator in at least 18 ISDS cases, according to Yusuf. Then we have Hugo Perescano, currently a consultant at Eurus. He acts as both arbitrator and counsel consultant in a broad range of international matters. He sits as arbitrator in both commercial and ISDS cases and has sat in around 15 ISDS cases. Prior to his current roles, Hugo worked for the Mexican government for many years, most recently heading Mexico's Trade Remedies Authority, and prior to that, general counsel for trade negotiations and part of the legal team during the negotiations in that. And finally, and not least, Gaila Gehring-Flores, partner at A&O's Washington, D.C. office, having spent 14 years previously as a partner at Arnold & Porter. Gaila has represented both multinationals and states in commercial and investment disputes for over 20 years. Native Spanish speaker, Gaila regularly represents Latin American clients. Gaila has been listed and recommended by Chambers, Legal 500, GAR, and other leading directories, and most recently was named as Latinvex, Latin America's top 100 female lawyers. So without further ado, let's get started with Jose Antonio.
Thank you, Nick, and thank you to Hugo and to the UNAM and also the Institute, and thank you for being here and believing in this World Arbitration Update. For me, it's an honor to be in Mexico. I will get down to the topic because I know that time is precious. So I've been asked to basically initiate our discussion with the topic of arbitrator conduct and relate to three main topics. One, which is issue conflicts, the other being repeat appointments, and the third one, the least controversial one, and being ironic, is the double hatting. So what I will try to do is simply put the issues for discussion, and then we will move into the more of what makes a good arbitrator and what makes a good counsel, which has been passed to my co-panelists. In terms of issue conflicts, I thought, how can we define it in plain language? And I came up with the notion, as I understand it, which is an arbitrator may have a conflict of issue if it appears that he or she has made his or her mind before hearing the case, and that is it doesn't have to be a certainty that that person has made his or her mind. It doesn't. I don't believe that there needs to be a manifest prior decision as to what the case would be, but it would be sufficient for there to be a conflict of issue if there are justifiable doubts that the arbitrator's impartiality or independence may be compromised. And the easiest way of sort of looking at it may be one of the initial cases in investor arbitration, which at the time was administered by ICSID, and that was kind of one of the first tests that I had when I was counsel at ICSID. The case involves a Canadian investor called Canfor versus the US, and in that particular case, the measures that the US had actually taken were anti-dumping duties and countervailing duties on imports of softwood lumber from Canada. There, the alleged investor, Canfor, named a former Canadian politician to the tribunal. And following the appointment, the US challenged that appointment. And on what grounds? Well, the appointed arbitrator had given a speech to a Canadian government council describing the US measures at issue as harassment by the US to Canadian producers of softwood lumber. So just think about, quote unquote, the arbitrator that had been appointed to decide on issues of investor arbitration had made a speech which was traceable, and he had called the measures of the US government harassment. So the question is, did he make his mind before? Or would you think that there were justifiable doubts on whether or not he could have, he would not be impartial? One big issue there at the time was the standard. What is the standard? Should there be absolute certainty that he had made his mind? Or would somebody with some reasonable intelligence, not even a lawyer perhaps, would have thought, well, perhaps he's not impartial. Perhaps there might be a leaning towards, well, the appointing authority, the deciding authority, excuse me, at the time was ICSID, and the deciding authority notified the claimant appointee that the challenge would be upheld. As a consequence, he resigned. And in terms of jurisprudence and in terms of history, I believe that this is an important case, not because he had made his decision. There was no proof that he had made the decision. The proceeding had not even started. But it was very telling that the standard is not necessarily that there should be absolute certainty that the person would decide in one way, but the notion of justifiable doubts is a very healthy one as to protect the integrity of the proceedings. So I will stop there in terms of what the notion of issue conflicts are, and I will move forward a little bit more into the notion of repeat appointments. Do repeat appointments by a specific party? Do repeat appointments by, thank you. Do repeat appointments by specific parties involve immediately an issue of lack of impartiality or independence? And there, unless there is evidence of either lack of independence or impartiality, I would like to take a step back and defend a notion that is the freedom of parties to appoint arbitrators, either claimant or respondent, and the freedom of those parties to select that arbitrator that according to their history, that according to their background, their educational background, professional background, etc., would best would be best aligned with a notion of interest. If they're appointing them, is because there is a notion of, well, this person might better understand the position that the investor is coming from or the position that the state is coming from. So I would like to emphasize a number of issues that are taken into account and that make that persona uh, more appropriate for either the investor or the state. And that doesn't mean that there's a conflict or there's lack of independence. It's simply whether any of you, as say, for instance, civil law lawyers, would better understand the position of the state or of a Latin American state or not, or an investor coming from Mexico or not. So that's really the background, what I'm referring to. So a number of facts or elements are important, including whether the person comes from a legal background where there was emphasis in public international law, the academic background, the commercial or civil litigation background, whether the person is more leaning towards an international commercial arbitration background, whether that person was a civil servant or not. All those factors do play into whether or not that potential arbitrator will be best suited to act as an arbitrator, not because he's going to represent one side or the other, but because he or she might better understand one perspective. And that doesn't mean that there's a conflict of interest. Moving along onto the issue of double hatting, and combining the issue with what should the arbitrator conduct be. On that topic, the answer has possibly been given a few weeks ago by the Ancestral Group 3, and also in conjunction with the announcement of ICSID that there had been finally an agreement in terms of what double hatting limitations are. So prescriptively, there are already, or there will be already rules. I would bet that in the deal that was agreed on in Ancestral Group 3 will be sanctioned, and that we will have a code of conduct. Now, that being said, what is the content of that specific agreement? In particular, what we have there is under Article 4 of the Code of Conduct, there is a cooling off period between the time that somebody sat as an arbitrator and the time that he or she can act as counsel in related cases or as an expert witness in related cases. The time limitation varies. We have 3 years in some cases and 1 year in other cases. Sorry. So ultimately, if the new case is related to a measure, or if it's related to a party of which the person was an arbitrator, then we have a 3-year limitation. If the new case is one related to a treaty or an investment contract related to the measure, we have a 1-year limitation. So that is sort of what prescriptively was decided. But beyond that, the notion of double hatting is one which in many ways divides the international arbitration community, because there are standing arbitrators and there are who have mainly been standing arbitrators their whole life. But I would claim that that's the fewer ones. And then there's standing arbitrators who have actually been counsel at some stage in their careers. And there's a notion of whether or not you can truly be a strong arbitrator and a fully rounded arbitrator if you haven't had the experience of being counsel before. If you haven't had the experience of fully know the procedural rules and doing the cross examinations and seeing both sides of the story. My personal perspective is that being counsel is a stepping stone in the creation of a fully strong arbitrators. And I can think of people who are no longer with us, including, for instance, James Crawford. He was counsel in many cases before, and even while being an arbitrator. So that perspective is one that I'm not entirely sure that should be relinquished. I have more to say, but doing so would be somehow disrespectful with my fellow panelists. So I will stop there.
I think let's bring it rather into discussion.
Obviously, it's a question that has many facets, Nick, because repeat appointments involve the facet of having been repeatedly appointed by the same party. Say, a respondent continuously repeats the appointment of such arbitrator, or such arbitrator is being repeatedly appointed by same type of respondents or claimants. In the arbitration community, you can normally distinguish between three types of arbitrators. The arbitrator that is primarily appointed by a respondent state, an arbitrator that is primarily appointed by claimants. And the reason there is evident because the individuals, the arbitrator may have a particular leaning towards the arguments of a state or the defenses of a state, or inversely, a claimant. It might be that arbitrators have worked as counsel previously, as Jose Antonio was saying, and as Jose Antonio was mentioning, they might have a particular experience as counsel for the types of parties that have had an argument such as those that are being expressed in that case. And then you have the larger group of arbitrators that is not defined as an arbitrator particular for claimants or an arbitrator particular for states. Now, should a repeated arbitrator, should an arbitrator that has been repeatedly appointed be challenged? Yeah, I think the answer is yes, but only if there has been a pattern that you can distinguish where that individual has been appointed either by a respondent state, say that the Republic of UNAM it has had several cases, and in several of those same cases, that individual has sat, and the other party already knows what the ideology of that individual is with respect to the claims. In those cases, yes, it is valid and it should, if I were to advise the other party, I would say, yes, do challenge because that is not an independent arbitrator there. That arbitrator has already, in repeated occasions, already indicated what her or his point of view is going to be. But that is not the case when say, a respondent state has appointed on several instances the same arbitrator in different cases, in different situations, where the arguments that are being addressed on claims under a treaty or different treaties are diverse. So I sometimes, as an arbitrator, I rarely have been challenged for reasons of lack of impartiality or independence. And the last time this occurred was quite a few years ago. I'm perhaps in the middle of those that I was mentioning, but I've seen arbitrators, I've worked with arbitrators who are within the other two groups, and I can assert that they are truly independent, even though they have been repeatedly appointed by the same state or the same group of companies that comprise a claimant. So the answer is not direct, but the answer would be affirmative if the cases in which that individual is intended to be appointed as an arbitrator have a similarity such that you can identify that that arbitrator is no longer an arbitrator who is independent because the issues to be discussed are already been addressed by that arbitrator in the past.
Well, coming back to the distinction that both Eduardo made, I think there's an easier set of circumstances to deal with, and those are where an arbitrator is repeatedly appointed by either the same party, either the same investor or the same state, or the same counsel acting for either or. But that's fairly easier because there are some rules or you take a look at the IBA rules on evidence, or not evidence, the on conflict of interest here, that they're called. It does, it states that it may create a conflict. It doesn't per se create a conflict. And the question is, where there have been repeated appointments by the same party and same counsel, does it really impact the conflict? I have been in that situation before. When the party that appointed me, or that suggested, told me that they wanted to propose me as, or appoint me as an arbitrator, we of course both knew that I had already sat on other cases involving counsel or party. And I said, of course, this will be disclosed and it will be open. And I agree that it doesn't immediately create a conflict, but we have to both be aware of it. The other party has to be aware of it, and let's see what happens. Sure enough, the other party initially raised the notice that they were going to challenge. And I think what's important is there really a conflict? So there were some initial reasons given as to why. As an arbitrator, I listened to what the party said. Ultimately, the party never raised the challenge. So, they were either satisfied that there was not a conflict and that I could remain impartial, or that there, it could probably be a successful challenge. Either way, ultimately the party said, okay, we're satisfied. At one point, they asked me to resign, and I said, look, it's not for me to actually respond to one party, whether I should or not. I'm cognizant of the party's rights. I'm cognizant of the rules. And if this goes to a challenge, I would like to see the gist of it before I say anything. So I really just sat back and stayed quiet. And the party ultimately said, okay, we're satisfied that Mr. Periscano thinks that or stated that he didn't act impartially, and we're satisfied with that. Anyhow, we could have raised a challenge, and I was aware, the parties were aware, it was transparent, and it would ultimately come to the reasons and to somebody else to decide on whether it really created a conflict or not. Either way, that's the easy one because we have some rules or guidelines there that tell you how to deal with it. And, there are arbitrators that may take a more combative decision. And in my case, I said, I'll wait and see what the parties have to say before I actually say anything further. And that seems to have satisfied the parties, and all was good and well. The other case, I think, is much more complicated. It raises a more complex issue because it really goes to impartiality. My view, and this is, I think, the generalized view, but it's not, there is no unanimous view to this in this respect. My view is that all three arbitrators have to be impartial, of course, independent. It goes to impartiality. So the perceived notion that there are, parties or arbitrators that are state prone or investor prone, I think it raises a complex issue for the system because it seems that parties are approaching parties and arbitrators as well are approaching the issue from a non-impartiality point of view. That is complex. And it's difficult to deal with. I thought about it, and I'm not sure if I were to write a rule or guidelines as to how to approach it. Of course, it doesn't fall into the other category, so it's not. I'm not sure that, that because an arbitrator has been repeatedly appointed by investors or repeatedly appointed by states creates a conflict. The IBA rules don't say anything. And they've been around for a long while. They've been revised. People have thought about them. And this doesn't create an issue there. So the challenge is not, I would say, that it's a matter of, or as a starting point, it doesn't raise a challengeable issue. But I think it does create a problem. Is the arbitrator being impartial or not? And how can you tell? As Anthony was saying, is an investor more comfortable knowing that it has appointed a particular person? I've been in this situation both as an arbitrator, but as well as from counsel. My view when I was counsel back in the day, I didn't, of course, as counsel, you want to win all cases. But that's unrealistic. There are, and especially in this area, we're more like, defense counsel. Hardly our client has, for instance, I worked at the Ministry of the Economy. It was usually other agencies in government or in other governments that were responsible for the measures at issue. So we were there just to defend the case. Think about a criminal case. The person who is being accused of having committed a crime, and you're there to defend him, whether he committed the crime or not. So my view is, as a state, and it's perhaps a little bit more difficult from an investor's point of view, but as a state, I need a decision that I can live with, a decision that doesn't create a systemic problem, not necessarily a decision that is in my favor, where, I worked in government for many years. I know that governments, for good or bad reasons, make certain decisions that affect investors or the community or the local competition, or that's what governments do. They step on many people's toes. It's difficult for governments to act, in a perfect way that they will not step. And many other considerations aside, like corruption and all that. Even governments acting in strictly good faith, they will step on somebody's toes because they have to deal with conflicting interests, including the government's own interests. So, I need a decision that I can live with, a decision that I can understand, that it is well-reasoned. People often say, well, you've won so many cases and lost so many cases. Meg was giving some figures. I was a little bit surprised because the 40% rate of return, so to speak, that investors get back, it's gone up a lot. Back in the day when I was keeping track of these numbers, claims, investors got back like 10%. So, when I'm hit with $100 million claim and the result, or take a case that Meg knows well, the Pope and Talbot case, where the claim was like $500 million, if I recall correctly, and the award was 250,000, 500,000. It was not even a million. Did Canada win or lose that case? And it's not like there were no measures that could be complained of. I mean, there were the measures there. So, but it does, coming back to the issue, it raises that more complex. And it may be that it has to do with the arbitrator's track record and career in the cases that the arbitrator has participated. How well reasoned? Because we're talking about a collegiate tribunals, and it's hard to say, whose input, what paragraph is whose input, and so on. But I think it has to do with that much more. I think that there is some work to be done in this outfit, but it does create a more complex.
Sorry, Nick, I don't think we can hear you. I think you need to grab the mic.
So I was just saying that I want to bring you into the conversation now, and we're going to turn to the more practical aspects of the discussion. Now, we're going to start with the ideal arbitrator. What makes the perfect arbitrator? And we're going to look at it firstly from the perspective of counsel, and then we're going to turn to distinguished arbitrators to give their thoughts. So Gaila, please,
Of course, thank you. Thank you, everyone. I am Gaila Gehring-Flores, and I'm an international arbitration partner in the DC office of Allen and Overy. Thanks to World Arbitration Update and UNAM and my fellow panelists. I wish I were there with you, and I very much regret that I can't be there in person. Unfortunately, a broken rib has kept me grounded in DC for the moment. And my kids would be very upset if I didn't say, you should see the other guy. As it turns out, yeah, there is no other guy. My broken rib is the result of a hiking accident. And I was lucky to just get out with one broken rib. But enough about my misfortunes in the wilderness. I want to talk today about the characteristics of an ideal arbitrator, but as I convalesce from my hiking accident, I thought it would be helpful to talk about these ideal arbitrator characteristics through the metaphor of an ideal wilderness hiker, which I clearly was not a few days ago. So 1, sure footing. That was one of my problems. You need to have sure footing as an arbitrator. Oh, someone's saying that that I'm too loud. Not the first time I've heard that. You need to have sure footing. How can you have sure footing as an arbitrator? You need to have competence from experience. And we've kind of batted around the concept of whether or not, how do you get that experience? Certainly one way that you can get experience is by being counsel in these investment arbitrations beforehand. You could also be an academic. You could be a judge in a national court as well. But I think it is incumbent on any participant in the system, and certainly an arbitrator in the investment arbitration system, to gain any experience that's lacking. And that can be had by just essentially studying the system. It is its own specialized system, and you really do need experience to have that sure footing as an arbitrator. You need experience with the different industry sectors that tend to pop up. You need to have experience in just disputes generally. You need to have experience in the procedure of investment arbitrations. And no, this is not a proceeding before your favorite home country court. It's a specialized forum with specialized rules and customs. And unlike urban myths, which Meg talked about and Nick brought up earlier, there are rules here. There are actually rules, and it's good to know about them. So next, so we talked about sure footing and experience and competence as an arbitrator. Next, you need to be untethered to go exploring in the wilderness or to be an arbitrator. What do I mean by untethered? You need to be independent. Clearly, you need to be impartial. I think we've heard enough about those two subjects. Those are very foundational subjects and requirements for being an arbitrator in investment arbitration cases, despite what perhaps many urban myths about investor-state arbitration cases say. Independence, impartiality. Don't be tethered to any one person, one party, one belief. You need to be objective and you need to be independent. And always err on the side of disclosure. I think that's always a good idea. Okay, what else? You need to be prepared. You need to be prepared for your adventure as a hiker or an arbitrator. What does that mean? Again, kind of going back to having sure footing, having experience, you need to be well-read into your specific case. You need to read all the documents. You need to read and explore the exhibits. Another way you need to be well-read, again, going back to sure footing and experience, is you need to be well-read in relevant international investment treaty precepts, jurisprudence, and procedure. Again, you need to know this stuff if you're going to be arbitrating this stuff. And I guess I should pause here. This is certainly coming from my perspective as counsel. I primarily sit as counsel in investment arbitration cases. So this is maybe my biased point of view as counsel and what I would love to see in an arbitrator. And then next, with respect to being prepared, you have to have and be able to use the right equipment. This is where this may have been my biggest downfall as a hiker. I did not have the right shoes on. And that was the problem that led to my fall. Now, as an arbitrator, what's the equivalent of the right equipment? I think it's technology in a sense, essentially. Are you fluent in today's technology? How proficient are you in all of the technology that we use and we need in these proceedings? You know, Word, Excel, chess clock apps, time zone apps, electronic signatures, scanning, scheduling apps, Zoom, Teams, and all of their trappings. Do you know how to unmute yourself? Are you sure you're not going to show up as a cat when you're speaking? Things like that. Let's be part of the world that we're in today. And the world that we're in today involves a lot of technology. And in fact, you know, going back to the hiking metaphor, it allows us to save some trees as well. Next, have a plan. Let people know where you are. Know when to ask for help. How does this apply to an arbitrator? Give the parties and counsel clear direction. And I think Meg had a reference to it in the new ICSID rules. There are now case management proceedings where I think this is an opportunity for arbitrators and tribunals to give the parties very clear direction on where things are going. Let them know, let the parties and counsel know where you are at. Let them know what issues need attention, areas of interest or concern, and ask counsel to explain or clarify. That's the equivalent of asking for help. I know no one likes to ask for help, but you should ask for clarification. You should ask for explanation so that all of the issues are truly heard. Also, have a spine. You need to have a spine as an arbitrator. Sometimes you're faced with difficult situations. Sometimes you're faced with rocky terrain. You need to face that difficult situation head on and with a plan, and not just with a sword to split the baby all the time. Make those difficult decisions. Give parties certainty and a conclusion, because I know there's a temptation to really split the baby and maybe kind of appease both parties at the same time, but it really does lead to inefficiencies, inconsistencies, and just general uncertainty. And we all know that in the foreign investment world, uncertainty is kind of our kryptonite. Also, if counsel or parties are engaging in bad behavior, going back to those urban myths, and this might be the one where there's a little kernel of truth to that urban myth. If counsel are engaging in bad behavior, stop it. There are consequences. There can be consequences in investment arbitration to bad behavior. Make it happen. Have a spine. All right. And last but not least, perspective. When you are going on your adventures in the wilderness, when you are going on adventures as an arbitrator, you need to have perspective. You need to have the ability to truly see and appreciate what is before you. And in the arbitration world, what does that mean? I think it means diversity. I think it means cross-cultural sensitivity. These things are needed for arbitrators to truly see the issues in front of them. And if you don't necessarily come from a particularly diverse background, then read into it. Read and increase your experience so that you might begin to see and appreciate more perspectives, not just the perspective that might dominate from white, patriarchal, colonialist, or neocolonialist experiences. Lastly, with perspective, you need to know your audience. You need to be very knowledgeable of the parties with which you're dealing. Counsel, the investment arbitration system, the world in a way. And why? Because the world is watching. Everyone is watching. And if they're not, they should be. And with that, I will end my comments on the ideal arbitrator.
Great, thanks for that description. Eduardo, how do you react to that?
I think Gail has some very valuable points. Thank you, Nick. I think Gail has some valuable points, some of which are to be considered by both the arbitrator and by counsel. And she mentioned as one of the last, know your audience. Indeed, the arbitrator has to know who the audience is, who the arbitrator is going to be addressing. But I think that's particularly more relevant for counsel, and I will address that later. She was mentioning cross-cultural sensitivity. This is critical. It's critical for an arbitrator to be not only sensitive to, but knowledgeable of. And Gaela pointed out correctly, an arbitrator has to be prepared, has to study, just as counsel has to study the case, and the arbitrator has to examine the case and case law. Cultural sensitivities may have to be studied as well. But the most critical point that I would find that an arbitrator needs is the ability to decide. You can have an arbitrator that likes to examine, address, but the parties submit a case to an arbitrator or to a tribunal with one objective. They want the panel, they want the individual to decide. And for me, the greatest responsibility of an arbitrator is being ready to decide. Where these are issues on procedure, or whether these are issues on the merits. But the arbitrator's greater responsibility, and Gaela touched on that, is the arbitrator needs to be ready to decide. And well, sometimes, you know, it's just as in domestic courts, as in international arbitration and investor state arbitration, it's easy to criticize the judge. When I was counsel in domestic courts, in some instances, I would say, how is it possible that a court can decide the issue? The issue was so easy for the court to decide. When you become a partner of a tribunal and you have two good counsel on opposing sides, it's not always easy to decide. When you decide, the first time that I formed part of a tribunal many years ago, as said earlier, in respect to also his experience, and the first time that you're faced with issues primarily on costs. How do you apportion costs when you don't have black and white, and you have many shades of gray? Okay, and we were criticized that we were splitting the baby in respect to cost. And I say, well, have you actually examined how difficult it is to truly identify the shades of gray? Because, you know, claimant did not prevail on all merits or behave perfectly in the procedure. Likewise, the respondent. Try not to get too near the microphone. So splitting the baby it's perceived as splitting the baby, but when a tribunal is faced with issues are not always white nor black. There's many shades, as I was mentioning earlier, of gray, and unfortunately, sometimes a decision in the middle is perceived to being splitting the baby, but the tribunal is quite cognizant that actually wants to avoid splitting the baby when this is not what it intends to do, of course.
Yeah, let me touch just on a couple of issues. I think Gala gave a a pretty good picture of what's needed and what people that sit as arbitrators should strive for. But one of them is being prepared. I think that is necessary. I mean, ultimately, as arbitrators, we're sitting there, we're rendering a service to both parties. And they should expect, and we as arbitrators should deliver being prepared. They submit a lot of materials, and they have a right to expect that they will be read and considered. And both as counsel, as and as arbitrator, I've seen sort of the two extremes. And it'll tie a little bit into the ideal counsel that we'll get into it later, but you know that it's important to let the parties know, you know, they are paying for a service, and they should get back, both parties. They're paying for. So being prepared, reading the materials, knowing the facts well. I've seen arbitrators that come to hearings with not much of a clue as to what has gone on.
Do you think there's anything such as over preparation? We're not trying to ever be over.
I don't know. I may fall into that camp. I can be obsessive compulsive in all settings, including being an arbitrator. My colleagues or former colleagues here can attest that I can go into the all sorts of details. But you know, it is to be expected. The parties have a right to have arbitrators that are prepared. The other topic that I'll touch upon is what Gaila was saying. Give the parties directions, let them know where they are. I think that one of the most important issues for arbitrators is giving the parties reasons. And I'll, you know, again, as counsel and as an arbitrator, I'll give you just a couple of examples. My very first case, the metal plant case, it was a huge case for Mexico. Thousands of documents, thousands and thousands of pages. Mexico submitted or offered 48 witnesses. It was a long hearing, and we got back a decision that was about 50 pages long. And once you took out the you know, the cover page and the contents, the table of contents and the procedural history, we were left with a 35-page decision that really didn't say much. Now, I can live with an adverse decision, but I think at least as counsel, I have a right to know why. And you know, because as an investor, I've invested money. I think that more often than not, that's the case. They've invested real money, whether they were right or wrong. And it states, you know, they have a system, and it is important to give reasons. It's important to let counsel know throughout the proceedings. For instance, the other example is the famous, or I should say, the infamous Redfern scandal. Who would have thought that Redfern would go down in arbitration history more for his Redfern schedules than for his writings and his insightful writings. But anyhow, I've often seen, you know, decisions saying, okay, denied for lack of relevance, period. So why is that? I want to know if it was denied, and especially as counsel, because I'll encounter these issues, probably not the investor, but counsel will encounter these issues. So I would like to know why a decision was accepted to admit or to order to produce documents or to deny the production of documents. And those are things that you can let counsel on both sides know as the arbitration unfolds. You know, are the arbitrators really prepared? Are they looking into the materials? Are they really centering into the issues? And of course, there are that's one example. But there, I've seen, you know, same thing, either granted or denied, or yes or no. I'm very unsatisfied with those decisions. I want to know the reasons, because I will be facing this tribunal for some time still. I want to approach the hearing and have a sense of where, the tribunal is at, what issues are, and it's difficult. I'll refer to that in a bit in more detail. But at least you're telling the parties, whether you are more or less prepared, more or less interested in the case before you. I think that's important. So reasoned decisions, whether it is on document production, on a procedural order, on a motion, and certainly and most importantly on the awards, that is crucial.
But now the final part, the part that I've really been waiting for is what makes the ideal counsel. We're going to hear from some leading arbitrators. Really, what should we be doing as counsel? What are the do's and the don'ts in this approach? Counsel. What I think.
Nick, it's my turn now. Now we'll criticize counsel. No, counsel plays naturally a key role. It's self-evident. It's often said that a good arbitrator makes good arbitrations. Not necessarily true entirely. I mean, it's good arbitrators and good counsel that will make a good arbitration. If you have a good counsel, the arbitrator will have his responsibilities simplified, let me put it that way. Let me start with 3 elements that make a good counsel and a good argument by a counsel. First, counsel should know his case. Counsel should know his adversary's case, and counsel should know who the audience is, which touches back on the point that Gaela was indicating earlier. A counsel who knows his case will be prepared, will organize the file, will simplify the case for the tribunal, because knowledge of the case makes explanation of the case easier to be made to the tribunal. We've all been there. If we know what we're talking about, it's easier to communicate. If we don't understand what we talk about, we'll begin evasive topics. We will not concentrate on what is key. So, counsel who knows her case must, as I said earlier, organize, prepare, and practice. When a good counsel appears, is to appear, let me say first in writing before a tribunal. This must be a well-organized case. It must be presented in a manner that is to be understood by the tribunal. And the easier, the simpler, the shorter, the better. I was discussing earlier with one of the individuals present and who's going to be addressing other topics in this conference, and we were discussing how parties like to submit memorials that are hundreds of pages long. Sometimes, in very rare circumstances, hundreds of pages are justified. In most cases, they're not. And in those cases where they're not, they are repetitious, they are disorganized, and sometimes there's quite a bit of unnecessary argument within the memorial to be presented. Sometimes it would appear to an arbitrator that counsel is addressing her client, his client. Why? Because it's impressive for a client to see a memorial that's several hundred pages long. And fortunately, we don't have today physical exhibits, or they're not submitted physically. But many of us here remember when submitting a case involved submitting exhibits that were not 2 or 3 boxes, sometimes a couple of dozen boxes filled with documents in support of the case. Gela was mentioning earlier that an arbitrator should read everything that's presented to her to him. Well, yes and no. That's where if a counsel is going to present dozens of precedents, show what portions of that precedent you do believe are relevant. Don't over burden the arbitrators with excessive information. There is extremely relevant information, there's relevant information, and there's trivial information. Don't burden the case with trivial information. So when you are to appear before a tribunal, engage with a tribunal, address the tribunal. They are your audience. You have to convince the tribunal. Engage, look into the eyes of the members of the tribunal. If possible, don't read your presentations. I know some counsel have practice and they do prefer to read materials because these materials go into the record. And it's easier to read a document that's going to be transcribed into the record. It's going to be read on the record easily. But that does not necessarily engage with the tribunal. That does not even allow you to determine what the tribunal is thinking about your case. When you address the tribunal, when you look into the eyes of the members of the tribunal, you can immediately identify whether your argument is being received well, received bad. When you're acting as counsel, understand your adversary's case and know what your weaknesses are and address those weaknesses. Don't try to hide them. The tribunal will find them anyway, so don't try to hide them, address them, and address in the best manner that you can with solid arguments. I have perhaps waited until the end for the element that in my view is the most relevant for counsel, and that is be honest, be professionally honest, be ethical. Be ethical and honest to your opponent, and be honest and ethical to the tribunal. You have duties to your client, but you have duties to the tribunal, and naturally you have duties to your adversary's counsel. Don't try to advance the position, or a counsel who is a good counsel does not try to misrepresent facts, misrepresent arguments, both in writing and orally. And I'm sure many of us who are here have seen that. It's amazing that the council would even think of doing it. Sometimes they do it simply to try to advance their client's position. It's not easy to have the weak case, the weak argument in the case. We've all had it when we've been counsel. We've always, we've had the weak case. But an arbitrator will immediately identify when you are misrepresenting a fact or misrepresenting an argument, a precedent. And when that occurs, your credibility as counsel is severely injured. And that permeates throughout the rest of the proceedings. But with this, let me, Hugo and I are sharing this third part of the section, and let's hear Hugo out, and if there's anything else, we can continue.
I think we're next.
Let's have just one thought.
Okay. One, just following up on what Eduardo said, what I think is the most important, or what would make the ideal counsel, is knowing how to navigate its case, or his or her case. And that touches upon a lot of what Eduardo and Gaela said, and what Saskia uses, Saskia Gambler. Be prepared. Arbitrators need to be prepared, but counsel needs to be prepared. They need to know their cases. They need to know how and when to shift focus, depending on what I was saying, how you read the tribunal. And of course, if the tribunal helps you in that, that's even better. So, a lot today, a lot of the lawyering and indeed the advocacy takes place backstage when opening statements, and after the very long submissions that the parties have made, arbitrators get hit with presentations that are hundreds of pages long. But what happens when the arbitrators have some concern? You need to shift focus and put your slides aside and talk to the arbitrators, let them answer their questions, or deal with their concerns, and so on and so forth. So that is kind of a roundup, knowing how to navigate the case involves prepare the case, so on and so forth. What I think would be the most important.
Just a couple of thoughts on what I believe makes a strong counsel. The tribunal wants to understand the case, and of course there might be two cases, one told by claimant and the other one by respondent. There's a narrative behind it. How well can you summarize the case? How well can you indicate to the tribunal this is what happened, beyond the chronology? The chronology is simply a tool, but beyond that, you need to put before the tribunal a narrative or a story that makes sense. And sometimes we think, well, it doesn't matter why, they just treated them unfairly, and there's an objective test, and that's all. Or they didn't pay compensation, and that's all we need. Objectively, maybe the treaties say that, but the human mind goes way beyond that. The human mind wants to understand why. And if the tribunal doesn't know why, doesn't have an intuition of why did it happen, then it's very hard for the tribunal to understand the story. I believe that part of the story is very important. So that's one aspect that I would like to emphasize. Other aspects include, of course, you want to summarize in what are the key issues, and there may be dozens of issues, but the case would normally, let's say on jurisdiction or on merits, will be decided by one or two issues that you have to focus on. Which ones are those? You have to choose them. The other aspect that I wanted to emphasize is what are the fights that counsel should be fighting? Everything. At least in my experience, whenever I've seen counsel fighting every little issue, it's a drag for the tribunal. They don't want to be having adults fighting like children. So are those some of those issues can be solved between the parties procedurally? Can you solve them like adults and then put before the tribunal those that counsel have addressed and tried to solve, but they have unfortunately not been able to solve? So that's more of an adult approach to it. And the last thing that I would say is that is very much connected to what I believe being an asset of counsel, which I believe you start with that. You might not finish with that. There is some confidence of the tribunal that your counsel and you would be, as in common law, we like to think an officer of the court, that you will actually help the tribunal understand better this case. That goes very, very well with what my colleagues have indicated, being truthful, being direct with the issues that are difficult, and not making untruthful remarks or fighting over issues that may not be central to the case, because as you go along during the course of an arbitration, if the arbitrators lose confidence in counsel as being truthful or ethical, then that may be the most precious asset that you had and you no longer have it throughout the course of the arbitration. So that should be taken seriously.
Guy, let's just let you have the last word.
Well, thank you for that. And I mean, it's hard to improve upon what has already been said. I, as counsel, certainly strive to meet all of those characteristics. But we're human beings. And one of the things that I'll note, just for instance, with respect to lengthy written submissions, one great area of tension there is just the fact that if you think about it, what counsel and investment arbitrations are tasked with is submitting in writing, essentially, an entire motion for summary judgment. And this is kind of catering to a US practitioner, an entire motion for summary judgment pleading and half of a trial in writing. The arbitrators need to have the case simplified for them. They need to know and have highlights and summaries of what all the witnesses and all the experts are saying. So I am actually, and Jose Antonio actually knows this, I am a big advocate for page limits in investment arbitration. Very few, now actually no tribunal has ever taken me up on it. I love the idea of page limits. I do think it makes it much more challenging for counsel because the challenge that we do face is quite great, given all of the information that you're required to distill in these, if you have a pretty complex investment arbitration at hand. And then I guess lastly, on Eduardo's comment regarding, professionalism, being honest, being ethical, I would certainly like to think that counsel who often appear before investment tribunals would consider themselves the equivalent of officers of the court. We have a duty to be officers of our profession, of our specific profession. And in this case, that is being officers of the investor state arbitration system. If you want to continue to have this profession, then you should, with pride, be officers before that investment arbitration system and present your arguments ethically, clearly. I hope that's a very, very low bar. But I do think it is incumbent upon all of us practitioners in this system to consider ourselves proud officers of this system and to be presenting arguments and behaviors in that system that we can be proud of and that don't lead to its destruction and that don't lead to these urban myths that exist quite strongly in the world today. So yes, I would love to see an investment arbitration bar of practitioners who are very proud officers of that investment arbitration bar.
Thank you for that very clear message. And it just leads me to
Just thought before for that, I must say, and also use of what Gail was mentioning, in no place have I found counsel so professional, so prepared, so experienced as I have in investment arbitration. The first case that I had was 23 years ago. I remember it well, and I came in as a substitute arbitrator for Mexican arbitrator that had fortunately become quite ill. And this opened a new world for me. For those who have not sat or have not read through investment arbitration cases, this is a place to learn. This is a place to listen, to learn. And I would invite everyone here today in this room and those that are watching. Investment arbitration is truly the highest summit of counsel preparation that at least I've witnessed.
We ask you to stay in your seat, and the next panel is for trade disciplines and damages, and it's going to be moderated by Orlando. So please.